Hello, this is the Corinna Open Lab seminar on December 8th, 2025. And today our special guest in the house is Corinna Coupette from Aalto University. And she will speak about computational perspectives on legal systems. The stage is yours.
Okay, well, thank you very much for having me. And I'm very happy to also be here in person today. Well, the topic of my talk, computational perspectives on legal systems, is actually short for computational perspectives on legal systems as complex systems, because that would have been a mouthful. But the complex systems part will be very important because if you look at this intersection between law, computer science, and complexity science, this is precisely where the research of my lab, the Talos Lab at Aalto University, Technology and Law for Society, is located. And so in the next approximately 40 minutes, I'm going to give you some input on how we in the lab think about legal systems from that computational perspective or from different computational perspectives, in the hope that then that will facilitate a discussion going forward on all the ways in which maybe we're totally crazy or wrong or out there, or maybe that might be interesting touch points for collaboration in the future. So let's get right into it by asking a couple of fundamental questions to make sure that we actually know what we mean when we talk about this title that I proposed there. And the first question that we need to ask ourselves is, what do we actually mean by legal systems? And so the way that we think about legal systems is we start very classically with this division of labor between the different branches of government, the legislative branch, the executive branch, and the judicial branch of government. There's also the private sector that we shouldn't forget about, even though as lawyers we're often trained mostly to think about law from the perspective of the public sector. In the public sector, we have a division, also horizontally or a layered structure, where in each nation, essentially, you have a national level, and then depending on where exactly you're located, you will have some structure below the national level. So that could be federal, state, and district level, and above the national level, which could be the European Union, in the case of Finland, for example, or of Germany, or it could be some other supranational organizations, or it could simply be international law. And then we have academia, which in law plays a special role in that it really actively interacts with all of these other parts of the legal system and tries to influence what is happening there as well, so legal scholarship there. And just to give you some examples of institutions or documents that you might have encountered and where they might be located in this matrix-like structure, if you look at the AI Act, that's a legislative act at the level of the European Union, which is a supranational organization. Then in the judicial branch, you have the European Court of Justice as a supranational organization, and the Supreme Court of the United States, for example, would be a national judicial body. The Environmental Protection Agency would be an executive body at the national level. And then you can even have kind of very trivial things like your local parking fine that usually gets issued by a district or so. That is a legal act, that's an executive act at the infranational level. A large part, again, of the structure that we see in law is contract. So even if you purchase a piece of bread, you're already making a contract. Normally, we don't see it that much, but especially when they become more complex, contracts might also be interesting to analyze. And what you already might see here from the different examples in the different boxes is that there's not only one type of thing there. So the AI Act is a document that has a substructure and that consists mainly of text and other things, depending on how you look at it. But then the ECJ, for example, is an institution. So the way that we look at legal systems is as an interacting network of institutions which employ people or have people acting on behalf of them. And then there's some other people or individuals just acting independently. And they interact or produce documents. And these documents, then for us relevant as lawyers, often contain rules where the documents themselves are not to be equated with the rules contained in the documents. And then all of this is indicated by the red arrow labeled T, evolves constantly over time. So every day in a legal system, you have institutions, for example, courts that render new decisions, or you have people making new contracts, or you have parliament discussing new legislative proposals. And so constantly what actually constitutes the law gets changed through these interactions between individuals, institutions, and texts. And that's kind of fundamentally the perspective that we have on legal systems. So when we talk about legal systems as complex systems, the next question, and this is just, I guess, in this audience clarifying here, is what do we mean by complex systems? So first of all, what do we mean by a system? Well, if you just take a dictionary definition, a system is a regularly interacting or interdependent group of items forming a unified whole. Of course, there's a couple of words in there that do a lot of heavy lifting, like what is a unified whole, for example. But let's just stay with our intuitive definition of what a system is for now. And then a complex system, trivially, is just a system that exhibits complexity, where by complexity here, we mean not the narrow information theoretic definition, but rather the phenomenological property that is characterized by a bunch of other properties that we tend to observe in systems. And so to give you a non-exhaustive list of such properties that would be indicators of a system being complex, one is a system might be characterized by interactions. And so we already saw that we have many interactions that are relevant in legal systems, where we have institutions, individuals, and documents. But even if you just look at the documents contain many rules that actually refer to each other and form this kind of directed graph type of structure of individual interactions, where the meaning of the rules together just emerges from their interactions. Which brings us to the next property that we might observe in complex systems, which is emergence. And you can simply describe this as like higher order structure that is not observable from inspecting the individual parts or their interaction rules. And one example where you find that in legal system is legal concepts. So oftentimes a legal concept emerges from the interaction of different rules and then the interpretation of rules by individuals and institutions, and it's not down-pinnable in any specific document. The next thing, which is pretty easy, is dynamics, so change over time, and legal systems have a lot of that all the time. The way at which we tend to observe legal systems is at a daily rhythm, but really the granularity at which stuff happens is even much more fine-grained and it's very continuous. So legal systems constantly change over time and they naturally exhibit dynamics. Then we have self-organization, which is related to emergence, but more focusing on like a high level function being achieved by the distributed kind of non-centrally coordinated interaction of many individual parts. And here you could, for example, locate justice as a higher order function of a legal system where no individual court can provide justice for an individual, and no individual parliament could do that. But overall, the structure and its interactions ensure that justice can be served. And then there's adaptation, which here is kind of symbolized by the chameleon adapting to its wide environment. And one way in which legal systems try to adapt to their environments, for example, is by setting incentives. So we might, for example, observe that some technology companies are not adhering to specific rules. And then as a reaction to that, legislators might try to increase the fines that might be handed out in response to violations of certain rules. Or we might actually change the rules to make them more incentive compatible. So what's important to take away here is that legal systems not only regulate complex systems, so they don't only try to steer behavior in society or try to regulate the economy or to achieve some goals of environmental protection, and all of these are complex systems themselves. They also are complex systems. So legal systems are complex systems. And that also means something for when we're trying to change them, because the moment we're trying to intervene in a complex system, that's very different from when we're intervening in some like logically structured hierarchical enterprise. So the question here that will be the guiding question of my talk is how can we develop computational perspectives on these legal systems that are complex systems? Which then brings us to the next question of what do we even mean by computational perspectives? So what do we mean by computational perspectives? Well, I'd like to start here with just a bit of an, again, non-exhaustive categorization of perspectives that we could bring. You could think of, different types of doing theory, different types of modeling enterprises. And again, this is very heuristic, just a way of kind of pre-structuring thinking to kind of see where gaps might be. And the first perspective that we could take is a descriptive perspective, where we're asking essentially, what is, so asking questions about reality. And then there might be certain fields like the qualitative social sciences or the humanities, or also basic descriptive statistics that again take very different approaches to describing this reality and trying to capture it through concepts or through numbers, depending on the flavor. Then there's a way of asking, why is it? So also that could be a computational perspective, which is more explanatory. So quantitative social sciences, natural sciences trying to do modeling, inferential statistics would be taking such types of perspectives. And then there's the new kid on the block, which is kind of machine learning and predictive modeling. We're not asking why is something necessarily, although that might be something that we ask in causal machine learning, but we're rather interested in what will be and trying to do predictive understanding of systems. And then, as a computer scientist, we shouldn't forget about the formal perspective, which asks about what is, but not about reality necessarily, but rather about abstractions of reality. And you find that in mathematics and computer science. And then, and this is where most of legal studies actually is this perspective that's prescriptive, and where we're asking not about what is or why it is or what will be, but rather what ought to be. So that's a should type of question. So what should the rules be is something that legal scholars really like to ask. And so most legal studies falls into this what ought to be bucket. So each of these perspectives could essentially also be something that's legal, although historically most of what legal studies has been in this ought to be bucket. But before we ask about what precise computational perspectives we would like to take on the legal domain, we need to distinguish two types of interpreting computational as an adjective to perspectives. And so one perspective is we're modeling the object as computational. So we're understanding legal systems as systems that actually carry out computation. And the other perspective is using computational methods to study a system. So that would be using computational methods to study legal systems. And because I like to throw terminology, you can roughly denote the first perspective, modeling the object as computational, as an ontologically computational perspective, and the second perspective, using computational methods, as a methodologically computational perspective. And ideally, intuitively, already you'd see, maybe we should model the object as computational and study it using computational methods. So we're interested in actually having ontologically and methodologically computational perspectives on legal systems and kind of defining what that means. So in most of the work that I'm planning to do and I'm currently doing, we're going to focus on both of these types of computational perspectives, also because it really becomes a lot easier to do ontologically computational perspectives or develop those using computational tools. And we're going to focus on these first three buckets, namely formal modeling, descriptive understanding, and trying to come up with mechanistic models that we might be able to intervene into, like basically agent-based models, for example, that might be more explanatory. That doesn't mean that we're not interested in the other buckets, but I do understand formal, descriptive, and explanatory as the foundations for doing anything else. And especially if you're in the legal domain, you think, we can prescribe things. Maybe let's understand the phenomena first, for which we're trying to prescribe rules. And so that's kind of the framework in which we're operating. Okay, so in the following, I will give you some examples of what computational perspectives could be, first using kind of ontologically computational formal approaches, and then using methodologically computational descriptive approaches. So to give you some idea of what we mean by ontologically computational formal perspectives, let's focus on how one might model and analyze legal systems as information processing systems. And so to give you a coarse-grained, naive computational model that I usually also like to use to explain to computer scientists at a very high level what we're trying to deal with in legal systems, this is trying to make it look as much like an algorithmic flow as possible. So we have external inputs that get kind of solicited by institutions that get put into procedures. And even just starting a procedure might also kind of already affect a global state of everyone else. Like the European Union says they're going to regulate technology, and everyone's already adapting to that, regardless of what the outputs are. But then we have out of our procedures specific outputs, and those outputs might have effects, where again, it's important that the outputs and the legal effects are not necessarily the same thing. So what we have with procedures as kind of the central building block that resembles algorithms in this drawing is they differ by the desired outputs that we have. And so it's like a type of internal data of the legal systems that we can observe. So outputs might be something like, court decisions or regulations or legislation or contracts or so on. So those are different output types. Then the procedures also prescribe which institutions need to be involved and how. So that's kind of data that doesn't get produced by the system itself, but it rather describes the system. So you could think of it as design data. And they describe how external input can or even must be collected and consumed. So that's external data. So we might have procedures that require us to gather information from experts or do a stakeholder consultation or so. And that's one of the ways in which the legal system can interact with its environment and pull in information from there. So the procedures, again, may already affect the global state, even if they end up not yielding any output or before they do so. And typically they run in all kinds of non-standard computational models. So, as computer scientists, we're kind of educated to learn about the Turing machine and the classic computer and all of its equivalents as well. But typically, the system that we're dealing with in legal is running online. So we're constantly updating everything. We're running in parallel and in distributed settings. So we have a bunch of courts, especially in larger nations, that do things that are only loosely coordinated and sometimes get centralized. But there's all of these kind of potential knowledge from online computing, parallel computing, distributed computation that we might bring to the table by understanding that legal systems are fundamentally not following that classic computational system. So that's just an overview of some more examples of external inputs, institutions, procedures, outputs, and effects. And these are kind of roughly row ordered, but not entirely. So, parliaments, for example, might conduct expert hearings to engage in a lawmaking procedure that will eventually output a statute. And that statute might contain then all kinds of definitions, prohibitions, obligations, or rights, which, computer scientists might be tempted to try and model in some kind of modal logic. But there's limits to what we can do there as well. And so this is basically just a non-exhaustive list of things that can happen there. And importantly, these procedures with their inputs, institutions, outputs, and effects might be potentially outdated, and they're essentially historically grown. And a lot of the complexity that we have in the legal systems of today is kind of grown out of a tradition that even precedes the printing press, but it was definitely facilitated by the printing press in the sense that we have a lot of procedures built around being able to kind of mass produce printed texts. And to just give you one example of where problems might come in, so here is the AI Act and the procedure that we used to arrive at it. And we started the preparations in 2021, and we're going to have like full applicability, which is not even actual full applicability, 5 years, more than 5 years later, in a space where we know that already what we did last year will be outdated next year. And here it's just like this, by the way, the time flowing from right to left is a Eurlex thing, which is not how you normally draw time. So we're actually starting here. And each dot is a procedural thing that we did at the different institutions in Europe. So you might ask, is this democracy? Does it need to be this slow? I would argue no. And potentially also if you look at kind of the content of this act in particular, you could argue that not everything might have gone in the same way that a properly functioning democracy would have liked. But this is just to give you an idea of the timescales that we're currently operating on with our procedures and the way that we're integrating institutions, but it could be different. So to give you another perspective that will also help illuminate how legal systems might be different is, and this is again taking the example also of the AI Act, for example, we can look at regulation as a reinforcement learning problem. So here I'm bringing up, a drawing adapted from MathWorks of a reinforcement learning agent. And, classic examples of where people have used reinforcement learning in the past is like trying to teach a car how to drive, or make it teach itself how to drive. You gather a lot of data and you do a lot of fine-tuning based on your observations, and you take actions on your environment. You observe some kind of reward, and based on your reinforcement learning algorithm, you update your policy for taking actions based on observations. And if you are to map a kind of regulation or policy making in general onto this diagram here, the agent would be a policy-making agency, and it could be, say, the European Commission, the European Parliament, or even just lumping everything together, the European Union, seeking to regulate artificial intelligence. And it has some procedures that allow us to observe the environment, and then eventually it takes action, and that action is actually through the means that we have to generate outputs. And our environment will do something with that and then give the European Union some reward based on how that's working. And importantly, that reward might also not be the same for the people who are acting on behalf of the agent and for the agent itself or its larger stakeholder structure. So this is the high-level idea, but now we need to imagine that both the agent and the environment are complex distributed systems, where, even in normal driving environments, you might have a complex environment, but the agent might not be a complex system. So here we have a legal system, and we just found that it's a complex system. And then we have policies that target a whole host of wicked problems. So wicked problems are essentially the ones where there's no clear-cut solution. I do have a slide on what wicked problems are from the planning perspective in the appendix. So anything like poverty, education, climate change, regulating responsible AI, those could be considered wicked problems, where even the solution depends a lot on how you frame the problem. And so lawmaking is all about kind of handling these ill-defined wicked problems that have many different solutions, where that's no clear-cut evaluation even. And we're still trying to do something like that. We're trying to influence our environment to get better and in some way know whether it's working. And at the same time, and especially in technology regulation nowadays, we have a lot of money that's actually seeking to distort our learning. So maybe our observations are going to be tainted, or our reward is going to be tainted by someone having a specific interest in what the outcome might be. So this is kind of the fundamental crux of regulation, that we essentially have a reinforcement learning setup, but we don't have any of the reinforcement learning kind of prerequisites. So what are some of the problems that one might identify when we map regulation onto this reinforcement learning framework? So if we talk about observation problems, that kind of range from just discovering information where we have only very limited channels for the environment to be observed by the agent. We have depreciation of information in the sense that it takes us so long to act that the information we observed to prepare our policy is already outdated the moment that we're actually starting to act on the environment. We have asymmetries in the sense that, oftentimes the people building the technology know better how the technology works, but they have no interest in telling us precisely what might go wrong there, because they have an interest that is not precisely aligned with ours. Some information we might not have because we have a new phenomenon and we don't know how it's going to work on the ground, because the new phenomenon is also interacting with a complex system where it's very hard to predict what's going to come. And then we have all of the V's of big data, volume, veracity, variety, velocity. And there's even more V's if you want to go on, where our legal systems don't really have structured processes for dealing with a large amount of data. So even if we had the processes to collect that data, we're not really good at knowing what to do with it. And on the action and reward side, we have institutional misalignment in the sense that, and so this is a concept that you might have heard in the context of social ecological systems, for example, where the idea is that if you want to regulate something, the realm of the regulator should be aligned with the impact realm of the phenomenon. And that's often not the case, because we have very spatialized regulatory territories, but increasingly many phenomena that are not spatialized or that are quite global, where if you do institutional regulation with a specific spatial confinement, then a lot of the phenomenon can just shift abroad. We have temporal misalignment in that it takes us way too long to act, see kind of the actions that we saw in the AI Act. Incentive misalignment, in the sense that the people having the information might not have the incentive to give it to us, or also the incentive misalignment between the regulators that are people and then the institution or even like stakeholders between them, we can only take indirect action. So we cannot change the environment directly. We can just say, hey, guys, please do this now rather than something else. So law at its very core can only set incentives. Even a prohibition is only an incentive to comply. And I think what we're increasingly seeing is also that people just estimate the probability of enforcement or being target of enforcement, and then the deterring capacity of a prohibition goes down rapidly when you just estimate that anyways nobody's going to enforce, or you can afford to pay if you get caught. And then the feedback, and this is an essential problem that even like predates all of technology regulation, is that we only get confounded feedback. So there's so much stuff that's happening in the real world, and even regulators do many things at the same time, that it's very hard to know, is this kind of going down of the crime rate, for example, that I'm observing in the real world, really due to my stricter enforcement or my stricter rules on a specific part of crime, or what exactly is it? Why are we seeing this impact? Is it an impact that is kind of causally related to the policy that we're making or something else? So I think this reinforcement learning framework, while kind of being a metaphor, really allows us to understand where some of the problems lie in our current legal systems. And in essence, our current legal systems, and this is at least my view, are made for and very much based on the 20th century information processing model. So where people communicated via large amounts of text, and also at the pace at which those could be produced. And one question that I like to ask, just to put a dot on the horizon, is, how would we redesign these systems if we could start from scratch today using the tools that we have today? So how would we make policies? Would we even make policies in the same way? Of course, we can't do that because we have path-dependent systems that will only ever evolve in a path-dependent manner unless we completely destroy them and build something new. But so if we had the freedom to design something from scratch, what would it look like? And this is just an overview of some approaches that one might take to start thinking about what these systems might look like if we could start over. And just to give you some examples, right now, the way that we're making policy, we're not really observing in any structured fashion how the policy affects the environment. We're not even observing how frequently specific norms are becoming problematic before courts. Like, we're not even doing the basic things like that. We could very much try to understand the observations at a more granular level from the data-driven perspective. And on the action side, we could be much more precise in the way that we make laws. We could try to make things computable to the extent that they allow for logical formulation. Not everything will be doable like that, but it could be done. We're used to making policies one for all. The way that we can now, in a very granular fashion, observe individuals and organizations, we might be able to tailor the policies that we make to specific characteristics. So this is a discussion that's in the legal domain held under the umbrella term of personalized law or granular law. So should we have different rules for different people? Of course, that's like a big rabbit hole that one can dive into, and there might be a lot of problems with that. But I would just like to challenge the assumption that we need to make rules at this very coarse-grained level. So I think one thing that's important to understand is that any rulemaking relies heavily on a discretization of the observation space. And that discretization is only as good as it is in kind of representing the underlying data distribution. So we might have categories that we use in law to tie legal consequences to, or that we use in our definitions that don't actually reflect kind of distinctions that we want to make in the real world, and that could be captured under personalized law as well. And then similarly, why should we have the same bodies determine the rules for everyone? And in the umbrella of kind of stakeholder governance, that's the thing where, if we know which people or which organizations are going to be affected by a certain rule, why won't we just let those guys or girls or persons decide what the rules should be? So, we can kind of gradually challenge one or several of the assumptions that go into how legal systems work today based on this reinforcement learning framework model, and see how it might change how we observe an environment, what even the agents are, what possible policies are, what the actions are, and so on. So basically, we could reimagine everything: inputs, institutions, procedures, outputs, effects of legal systems. And then the question becomes, should we? Because maybe that's a thing where a lot of things could go wrong. So my intuitive answer is probably yes, but we have complex systems that we're dealing with. And if we know anything about complex systems, is that it's very hard to evolve and predict them and engineer them. And so we have no good theory for legal systems as complex systems. And that's a problem if we want to start thinking about how we should do these things. And so the catch here now is we don't have a good theory yet. So part of my research agenda with the lab is to develop that theory. And this is also precisely where then methodologically computational descriptive approaches come in. So here now we're shifting gears from just treating legal systems as computational systems and probably bringing to the table all kinds of different disciplines from computer science to modeling and analyzing legal systems as complex systems. And so the main inspiration for that line of work is network science, unsurprisingly probably, because complex systems are naturally modeled as networks. And so I understand that a lot of people, at least here in the room, are familiar with what networks are. So I don't need to tell you that networks are naturally represented as graphs and that there's a lot of nuances that we might need to take into account here. So just a brief recap, to make sure that we're all on the same page what we're talking about here. For networks that we model as graphs, we usually have a node set called V for vertices, which is a mathematical term that people use in graph theory. And those nodes, and you can think of, for example, people in a social network are connected by edges. Simple example would be friendship edges among people. And those are drawn here now in red. And then when we're talking about legal systems and modeling them as networks, we'll quickly find that this basic model is not at all what we need, and we need much more expressive models for modeling legal systems as networks. So usually, we'll assign unique identifiers, which will allow us to compute nicely using adjacency matrices and all kinds of, linear algebra mathematics, which is one of the powers of graphs as representations of networks. But what we ultimately need is not simple representations, simple graphs like this, but often in law, we'll have directed graphs. So you'll have one court decision, for example, citing a bunch of other court decisions, and those will be naturally directed relationships that we have here. We'll often have multiple citations between documents, which then could be represented as weights or as multiple edges, depending on how you want to look at it. If you want to assign both multiplicity and weights, then you need to go with a weighted multigraph and so on. But this is all nuance that we can represent. We can add attributes, and this will be very important also in legal systems because that allows us to filter and aggregate and group by in all kinds of flexible ways before we're even looking at graph statistics that we might want to derive. Change over time is very important to capture in legal systems as well. So we'll have temporal graphs for that. And then hypergraphs are a thing that is also increasingly becoming explored in the legal domain because we have phenomena where, for example, a legal argument is constructed by the co-location of multiple court decisions that make different points that need to be considered in unison. And that would be a classic case of a hyperedge where you might have more than just two constituents. And so basically here you go from having a tuple to a set. And then multi-layer networks, a natural representation of multi-layered legal systems. So you might have kind of Estonia, for example, as one layer, here layer 2, let's say, and then that's clearly influenced by European Union law. And so you'll have some citations go up to that other level, and then you have that European law level as well represented there. You can think that there's also kind of international law and so on, and there might be multiple layers too for different countries, and then layers below that. So multi-layer networks are very powerful in the context of law as well, although that has been barely explored as well. And so the way that I think about legal systems as networks is that by combining many ways of looking at legal systems as networks, we can gradually work toward building digital twins of legal systems. And to give you an overview of what that means, one type of network that we'll have is textual interactions. So you'll have say, jurisprudence, court judgments, or paragraphs of court judgments referring to each other in some way with weights and directions over time. We might have social interactions between the people who actually make the laws or between the people who get to vote on, parliamentary legislative proposals and so on. We might have textual structure. So a lot of the legislative documents, for example, have a multi-layer hierarchical structure where you'll have a legislative act that's kind of broken down into chapters and then sections and subsections potentially, and then you'll have unique identifiers at one level. So we have intricate textual structure, and that structure is built quite deliberately to also convey meaning. And that gets mirrored on the institutional side by institutional structure, where we might have a court, and the court might have different panels with different competencies, and then each panel has a number of judges that are associated with that panel and take decisions on behalf of that panel. And then we have a bit more complicated stuff that still has kind of a network element to it, but that is not straightforwardly representable using the network models that we currently have. And the first element of those is institutional interdependencies. So what institutions, for example, need to work together to appoint a judge to a court or to produce a new legislative proposal. Might be several chambers that need to work together there. And that's something that fundamentally is kind of an algorithmic interaction built in on top of a kind of interdependency graph. And then we have things like textual interpretation, where one institution might say, okay, this document actually conveys the right of this individual to produce this other type of document, and then some other institution might actually say, no, that's not the case. So we might have rivalry between interpretations, and that's another kind of network key phenomenon that's not easily captured by what we currently have. And so the goal, working toward digital twins, would be to gradually integrate all of these different types of relationships between institutions, individuals, and texts. And again, this is not exhaustive, into an integrated representation that you can then flexibly filter, aggregate, group by, and combine. And if you think from kind of the status quo, the first four up there that I delineated are pretty easily handled by existing models, although even there you need to be careful to not get the network modeling wrong. I might talk about this more later. And then for the other stuff, you kind of need to go beyond existing models and incorporate more kind of agent-based modeling type operations potentially to get that into our representations. To give you a bit of a background on the prior work that we've done, and also because I know this is kind of cultural data analytics, and you also like to do artsy stuff sometimes. So here's one way of thinking about law as networks based on modeling legislative documents. So here's a section from the US Code. And then if I look at this document, I see a hierarchical tree structure. So you go like US Code, Title 15, Chapter 1, Section 15. And that's the uniquely labeled identifier. So the section number usually is what people refer to at least. And then there's multiple levels of hierarchy below that. So you have the A, B, and then 1, 2, 3. And even below that in the slightly green highlighted thing. So you have this elaborate tree structure. You might see, if you look closely, that there's a citation to a different title, Title 28, Section 1605, something, something. So you have cross-references, which are kind of directed edges that are not inclusion edges. So we have a hierarchical structure, a sequential structure, which is kind of Section 15 and then Section 16 and so on. Sometimes you have A and B there if edits need to kind of keep the sequence. But there's like one level at which you can basically address all kinds of legal norms, and that's guaranteed to be there, and that's a sequential structure. And then we have references or reference structure, which is basically legislative documents referring to each other. And that also is something that you see in court decisions. So court decisions, depending on where you are, will cite legislative documents, not often the other way around. But so you get the citing up, and you get reference structure within these document types, but also across document types. So what does this look like if you just take, say, one statute? And now I'm going to give you some examples of data art, in this case from Germany. So this is the German Income Tax Act. If you just look at the hierarchical structure, And so here is kind of the top note that just says ESTG, which is the Income Tax Act, and then it's like a chapter structure, and then it goes below. And here is kind of the sequentially labeled structure, which is not always on the same level. So sequence goes this, and then here, down here, and then up here. And below that, there's one level of kind of paragraphs. So section 1, paragraph so-and-so would be represented. I didn't resolve the structure below that, but you already see that it's quite intricate and actually, from the aesthetic point, quite interesting to look at. You might ask what happened here. And then there's like a specific reason why that is. But now you can overlay citations, and it looks like this. And if you distinguish between forward and backward citations, you get flow like this. And this is what one law does for you. And so as a lawyer, you need to kind of navigate this mess. And not only that, but this act will also have references outgoing to other acts. Normally there's more internal stuff than outgoing stuff, but you'll also be pointed to many different other acts. This is the Constitution in comparison. So what we see here immediately is that this guy is much more nicely structured, right? So it's all kind of on the same level, it's pretty clean, and it's not as messy. So here's some more examples. And I try to color code them in like, colors that would evoke some meaning. So this is kind of like noble night sky German Company Act. Looks pretty similar in hierarchical structure to the Constitution. One of the reasons being that this hasn't been touched that much. It's a pretty old law and people haven't ruined it. Then we have the building code, which is here in like green and brown, which is evidently like a lot of complex regulation. And we have the Asylum Procedure Act, which started out a couple of years ago, much smaller, and now we have a whole bunch of other acts that look like that. But this is actually not the largest that we have. So the largest is our German Civil Code. Although large is here like used very untechnically, there's different ways of determining large. We start here, and this is how it goes around. It's 5 books. You can overlay citations with edge bundling, which was kind of nice. And then again, distinguish like outgoing and incoming, or like forward or backward within the textual sequence. And this is, for comparison, the German Criminal Code, where what's interesting is that this is kind of the general part where it's like, this is how criminal law works. And then this is all just different types of crimes. So this is very tidy. And here we see the most granular structure also in the common parts. And then there's sometimes a huge mess and sometimes not. And that kind of depends on how political the material is as well. So not all parts of the civil code change equally fast. We can also do this for European regulation. And one thing to note here is that in Europe, we have preambles, which is basically legislators saying what they meant before they reiterate everything. So what I'm doing here is I have the preambles down here, then I have the actual tree structure up here, and then now growing like a proper tree and not like a computer scientist tree. And I have the number of characters or tokens, I forget which exactly I counted, going up or below to just show how much text there is. And then there's, again, the familiar citations. And so this is one of the, this is like Eurodac governs a fingerprint database in the context of asylum law and the common European asylum system. That's pretty important. And, now I've shown you a couple of examples of isolated legal trees, but what we have ultimately is ecosystems. And now this is a very condensed representation of ecosystems. And this is also very much work in progress. So, don't trust my regexes on this. So what we're dealing with here is we're pulling data from the backend of the European Union EURLEX database. And because it's not properly annotated for cross-references, you actually do all of that yourself. And here I'm kind of coloring and scaling the edge thickness by the amount of edge flow, citation flow from one regulation to the other. These are all 2024 regulations, and the different numbers are all part of the common European asylum system. And I started working on this because I was talking to people from one administrative code in Germany, which currently deals mostly with this. And they were complaining about how, they needed to navigate all of these, and they basically have printouts or they have digital texts that are not properly interlinked. And so these are kind of the references that then manually need to resolve and navigate. And so what we see here basically is that for one of the kind of most disempowering areas of law that we have in Europe, there's a very complex legal situation, and it wasn't always like that. And if you listen to the practitioners, fundamentally, what the rules are has remained the same. We just have a lot more bloat in the text and the interconnectivity. So that's a classic case where even intuitively you can see that there's complexity in the legal domain, regardless of how precisely you might measure this. And so now to just give you a brief glimpse of the work that I'm planning to do with my lab in the future. And this goes, again, to this idea that to understand how we can make our systems better, we first need a good computational theory of legal systems. And that theory, again, would be both ontologically and methodologically computational. And so this now is basically giving a brief overview of the work that I'm planning to do over the next 5 years in the context of an ERC starting grant called Complex toward a computational theory of legal complexity. And this is really trying to take the approach that we take to complex systems and map it onto what it would mean for legal systems. And it starts with the observation that complex systems are characterized frequently by their structure, function, and dynamics. So we're naturally kind of bucketing or having a work package structure, basically, where we look at the structure, function, and dynamics of legal systems. Where structure you can intuitively think of as, what institutions exist, what can they do under which conditions, with what other institutions. Then function is what does actually happen in practice, like not everything that's possible might actually happen. What are the activities that we observe? And then how do structure and function co-evolve over time? Because law has this weird thing that we also have procedures that allow us to change the structure of the system or even the ways in which we can change things. So that's dynamics. The next observation is that in the theory of complex systems, we work to capture, analyze, and explain them, which gives us a task structure where, first of all, we're aiming to capture what the structure, function, and dynamics of the law is by essentially mapping it. So you're collecting data and you're visualizing it and you're making it computationally amenable. Then you try to make meaningful measurements out of it, where construct validity is the main challenge everywhere. And you'll find that often for even measuring something, you already need to kind of incorporate in some way simulations, and you need to deviate, for example, from the standard metrics that people might be inclined to use in network science or in natural language processing. And then mechanistic models is basically trying to get toward the point where we can look at, okay, let's assume we change a policy like this, what's going to happen? So you can try to kind of do counterfactual exploration, which in law you can't do in the real world, but at least we can build model systems in which under certain assumptions we can say that, if we do this, that is what will happen. And to give you a bit more intuition for what we're after here, is when we're looking at the structure of legal systems, one of the kind of very contemporarily important questions is how we can protect democracy from hostile takeover. So how do we roughly ensure that our legal systems are robust to attacks? Then, of course, you might ask immediately, what does robustness mean and what is an attack? And defining that will be part of the process there. But the picture that I'm trying to draw here is, for example, that what is happening here in the static picture is that you get a majority that's red in one institution, and that kind of causes everything else to go red and disempower the guys who used to be black and are now gray. And so through institutional interlocks, if you have institutions that are not adequately protected, like in this case, a court, for example, what might happen under certain situations is that if you get a majority over here of, say, some extremist party, they can actually block all of the activity in that other part of the legal system. And it's very hard to keep track of this right now. And we've had a couple of cases in the real world where, for example, in Germany, people woke up last minute, oh, we need to protect our constitutional courts, when it became a real scenario that we might have extremists blocking minorities or even now majorities in certain state parliaments or even at the federal level. And so, having a model by which we can analyze the levels to which individual institutions or systems themselves can retain their function at the structural level might be valuable. Then on the functional level, we're looking at resilience to failures. So what happens say if we have a proposal and it's about, this is a recent case from Germany, we want to do some regulation on retirement that will effectively potentially harm our future, and there's some people who disagree, then there might be one route in which we can try to find compromise and come up with a hybrid proposal that will get a majority. Or we can have a scenario in which we're more adversarial, where, here in this case, in the drawing, the blue guys go to court and they have a blue majority court and they'll get a blue proposal in the end. So how do we design our systems to enable compromise over confrontation, and what does compromise even really mean? How do we measure something like resilience in legal systems? This is one question there. And then on the dynamic side, and this is potentially, where many people would intuitively like to start, we have AI now coming into legal systems, being used by legal practitioners, by people trying to access the legal system. How is that going to change all of how our legal system will work? From the internal perspective, this is a challenge of responding to a new thing that developed outside of the legal system. So we now have this new technology and all kinds of new things are possible. How do we adapt our rules? And also, how does the system change by AI being used within it? So all these questions are questions about the impact of AI. But to measure the impact of AI on legal systems in any meaningful way, we need to even know how we can measure change or how we can measure adaptation to change outside the system. And all these things are things that we effectively don't know to do. And that depends on all of these other things. At least, that's one way of looking at it. So this is kind of the work plan, what we're planning to do in the next 5 years. And with this, I think I've talked more than enough. I thank you for your attention. If you want to learn more about our work, this goes to my website. There's a part called publications. You can get an idea of what we've been doing in the past. Currently, I think what we see with the backlog that we have is that we're much further in thinking than in publishing. So if you feel that any of that resonates with you, please feel free to reach out via email and be happy to chat, or also chat now live and perhaps come up with some collaborative ideas as well. Thank you.
All right. Guys, Mike clapped on video. The audience who sees this later will not see the clapping because Zoom doesn't cut it out. Thank you very much. This was great. Let me zoom out a little bit so we see everybody.
Should I stop sharing?
If you like, or you leave it on. I don't know.
There's a lot of information there.
There's a lot of information there, exactly. Let me switch on my camera here too. So yeah, I think I noted down a whole host of questions. There's a lot of questions I have, and probably there's also questions in the audience. There's lots of overlap with anybody who has worked on text, anybody who has worked on classifications like library classifications, like the internet and so on. You come up with these sort of coarse-grained network models where every node is a tree or a network itself, which reminds us of the linked data cloud. So basically, it seems like you got a sort of like formal domain where a lot of stuff resonates with things that is way less formal in other systems, which are also structural, functional, and dynamic, and where we have an equally hard time to sort of like do that kind of measurement, right? So in the humanities, large-scale cartography of entities is sort of something which still you have to sort of excuse yourself for doing it anyway. And if you want to publish the diagram, like my favorite one is like I went to the Burlington magazine and wanted to publish a large visualization about the people that their whole journal is about, and they said we don't do diagrams. But it's the journal about drawings, and like if in the Renaissance somebody would do a diagram, they would do that. So one of the key questions here is how do we sort of like how does this relate to classic practice among the constituents that do the same thing you do, but qualitatively, like people who sit with their orange little books in the Bavarian State Library and read the same law that you cartograph here in a nice tree. So what do these people say?
Well, I mean, first of all, so I can say empirically, when we had an exhibition of legal trees at my law school a couple of years back, that people were like very intrigued because they've never taken that bird's eye view on the system that they were operating in. And then I do think that it's actually not as far from them as they think, because everyone's using legal information systems. And a lot of the times, people actually intuit the problems that we're trying to address when they complain about the information systems that they're using, so that there's no links, that they might just have a court decision presented with a list of other decisions that get cited without any meaningful ranking. These are things that we kind of know how to do, that we know how to do in web, we know how to do elsewhere. We could use NLP, we could use networks, but there hasn't been historically an incentive on the legal database providers to really do that, or at least it's not implemented as universally as you'd think. And just recently, Eurlex, for example, the place where people go to consume European legal data, and the European lawmakers are very proud of what they're building there, and they're adding all kinds of experimental features, but it's still fundamentally unusable. So I think when then people see that, it kind of resonates a lot, but it also blows their mind in many ways. And the moment that you go to graphs, people are just also often kind of formally lost. So I think this is one explanation also for why people now do more language processing stuff, because it feels like you need to know less of mathematics to do it, which is wrong. To do it correctly, you also need to learn a whole lot of statistics. But I think graphs themselves as a representation, when you don't even know what a matrix is very far off your territory. The visual approaches and diagrams are used in textbooks as well, for example, to depict legal situations, like you have this person is buying that object from that other person, and now this happens, but then it's all very poor drawings. And I think the observation that lawyers have very low visual literacy as well, and that a lot of law teaching could be better by being more visual, has also been made by others. There's legal design that tries to bring a lot more visuality into law there as well. But fundamentally, I think people recognize that there's a need for that, and that there's also a way to complement what they're doing, because nobody can read. You could say read all of the Federal Constitutional Court jurisprudence. It's several meters of text. As an individual, I doubt that you'll be able to make a lot of sense of it, except for intuiting something that you picked up over time. It'll take forever. But you definitely can read all of the Federal Constitutional Court jurisprudence and everyone else's jurisprudence, plus all of the applicable laws at the same time. So I think this idea of can we combine close reading with distance reading? Can distance reading help guide close reading? Can any of the derivative measurements help us navigate the information landscape better? Because everyone in law is complaining about growing complexity, growing regulatory complexity, legal complexity, without having a concept of what they actually mean by that. So I think it relates intuitively to the concepts, but you need to explain to people, oh, this is actually you need to take them to where you are a bit.
I would like to pick something up you said, which has to do with the fact that how you do it, which is to some maybe frequently simple. You take these databases and then use regular expressions. So it's functionally you take a technology from the 1970s, and then you draw trees, which is a technology of the 1990s in some sense, and you produce a result which is surprising to people in 2025 who are sort of regular legal scholars. And the database companies didn't get their act together in doing this for 50 years. So at the same time, you hinted that people now use large language models and whatever to classify stuff and whatever. And I do hear some criticism in your sort of the way you say it. One of the neat, elegant things about complexity science is that you can do very simple things, reduce a person to a point, the friendship to a line, and then run some rather simple algorithm that may be computationally hard, but then sort of have a neat network diagram. What you're doing here is even more simple, but you reveal this complex structure. And would you argue for, instead of having ever more sophisticated sort of black box machines where we don't know what they're actually doing, to actually harness these kind of like really simple tools, such as regular expressions, command line, whatever.
Well, I mean, I think Occam's razor still is a good principle to follow, and I think if we haven't even explored the simple things, why would we come up with more complex things? I can tell you why, because it's like better to sell and to get money and funding and so on. But ultimately, so like the problem also of many database providers or legal data providers is they don't have their data together. And it's if you have a pile of garbage that you're learning from and you don't put the structure in that lawyers actually put in there, but it's not represented in the computationally amenable format, then you're going to have so much more of a harder time to get to a point where you can generate wisdom. I also would say it's not exclusive, but we need to clean up the data first. And that's kind of by putting in what's already in there in terms of like knowing where the named entities are, knowing where the references are, knowing what the structure is. We can also, by the way, do all of the computational things. We can do clustering and other things. The way, like what I showed you was kind of the visual representation, which I already find quite striking, of these individual legal trees. You can do all kinds of normal, quote unquote, network measurements. And we also did that in some of our prior work. But I think one reason why we're not seeing more like simple, like adoption of simple tools is simply that people would need to do the data work first. And so in a way now what's happening is there's like legal database providers acquiring legal AI startups, and everyone's like talking about the cool thing that they're doing. What they're then doing is essentially just like using some retrieval augmented generation on the pile of garbage that they have in terms of data. And then like there's so many simple ways I could tell you that would improve your outputs there. So, if you know the structure and you know cross-references, you know entities, like I can see like a use case for RAG without the structure when you don't have structure. But I think also, and this is kind of what distinguishes legal also from many less structured domains, is we know all of the structure, and it's semantically meaningful, which is also, it's like not arbitrary. Like a legislative document isn't drafted fast. People think about like what should the headings of the sections be? Should this be in this section? Should it rather be elsewhere? Where else should it point? We have this thing that by making references, we incorporate content from elsewhere into what the rule is. So if you're taking a naive approach to large language model, like just throw everything in and try to retrieve something from context or so, you'll miss out on that. So like there's data pre-processing that you need. And ultimately, I think a lot of these problems you can resolve already at the data level. And once you have properly clean data representation, you can actually use explainable, interpretable, scrutable methods to get a lot out of that before you need to go to the black boxes where you don't understand anything. And I also think that it's a kind of a question of kind of rule of law or access to justice, because like just not having any explanation for why you get this particular output might not be what we want. I'm not saying that it's impossible to generate explanations, but I mean, I think the role of kind of explainable AI in the context of language models is also quite questionable. That's a side discussion. But I think in general, why not start with the simple things and see how far we can get before doing the complex stuff that takes all of the time and money and whatnot. It's a bit also just intellectual laziness, honestly, because it's like, it seems very easy to just throw everything into a large language model and act like you're doing science, but you're not.
Please, in the room, if there's questions, raise your hand if you have, because like otherwise I will come up with other questions. I have one that's sort of like covering the opposite side. So one of the interesting things here is like I mentioned, there's library subject classifications has very similar structures. You have a tree structure, there's redundance, there is alias links, you have links to other things, and you run into the same kind of issues. People have sort of, for example, mapped the tree structure in the discussions in the city government of Venice, where there's like 23 kilometers of documents, which results in a very similar tree visualization. And the people who do it are people like you and I, physicists who like to do network science, who get a knack for, in this particular case, I don't know, historical sort of like governance proceedings. And just like judging for myself, and I'm pretty sure like Corinna on a couch in the office will have the same kind of like thoughts. You probably don't think the same things than the legal scholar who sees this for the first time in the hallway of a government building, or people who see this for these companies who see this maybe as an evaluation of their own database, which obviously is scary to them. But you may think other things, like, for example, what's the Wiener index of that tree, and what's the Wiener index of that other tree, and what's the physics of how this tree accumulates, and what's the probability that there will be a reference to, like, how far in the tree will my reference go, and so on, the next one that appears. So these sort of like network dynamics, which are almost, you could say, in a superclass of your domain, which is law or legal systems, like, does this belong to computer science? Does it belong to complex systems? Like where would you locate that, and what ultimately is the potential of that? Because I think we need to carve out spaces where we can actually have these thoughts without having these thoughts sort of like while at home, taking a walk, or sitting somewhere while something else is going on. But we should actually focus on those things because they really sort of like help us understand what's going on, isn't it?
Yeah, so I mean, like, I'd say all of the above, I guess, or like why a single category, or why categories in the first place. So I think there are like definitely a lot of the things that we're doing or that I'm thinking about are computational, but they're also not really like computational in the same way that classically trained computer scientists doing like classically publishable work at, say, a top machine learning venue or a top theoretical computer science venue would do. So, like TCS people have very clearly defined problems, and they work on these clearly defined problems, and, have all kinds of wicked problems where I first need to find out what the formalization is and so on. And there's like subfields there that are closer to what I'm doing, what we're doing. It's like computational social choice, which wrestles a lot with the issues of how to formulate a problem that's fundamentally social in terms that are still amenable to analysis and computation while not stripping away too much of the semantics that's relevant from the context. And in machine learning, depending on where you are, you're essentially just trying to get numbers down on benchmarks. That's a very different mindset with which people come to that place. And so classically trained computer scientists are not inherently more capable of doing the type of thinking that I need my people to do than someone who comes from a completely different field. I think complexity science, or like network science in general, being a more methodologically oriented and like more domain agnostic field might be more amenable, but having been around there for a while as well, what you see there is also that oftentimes there's not enough of kind of taking the context into account, or like we're kind of missing this middle layer of abstraction between the people who are doing the method stuff and the people who are doing the domain stuff. And I feel like, so, the kind of primitives that we try to use for communication are not at the right level of abstraction, in the sense that, as a network scientist, I might care about developing methods for a certain type of problem, but I'm kind of lacking the type of characterization or typification of problems that would allow me to kind of have a meaningful mathematical or computational category that kind of maps onto something that's semantically meaningful. So kind of bridging this gap between domain and methods, I think we need spaces for that. And then those like benefit from having more and more domains, I would feel, because that's what allows you to discover kind of the common types or shapes of problems that are persistent across different fields, so across legal and economics and political science and so on, or maybe even like biology and something completely different. And so I do feel that, for example, like the primitives that everyone talks about in network science, like centrality and communities and degree distributions, so those are the things that we think we've discovered across all of these domains, but I'm honestly not sure to which extent that's kind of put in by the way that we're modeling things in the first place. And also, especially in the context of centralities, historically, people had a very strong motivation from the domain for a specific type of measure. And that just kind of got lost. And people now, when they get taught they get taught to use kind of network X and Python and so on, press play, Zachary's Karate Club, you do the different community detection methods and so on, and you don't ask like what is the mathematics behind that and what semantics does the mathematics map to. And I think the kind of training that I want to give people is, what semantic issue do we have and what mathematical primitives can we use to attack that? And then like putting that together in like a computational structure, and then you have an algorithm. And where does that fall? I mean, it's definitely computational and it's definitely like it's semantically embedded, so it's domain as well. But I don't really see, like it's inherently, say, transdisciplinary probably, in like depending on how exactly you use the term. So like in the sense of like blending disciplines, not going beyond disciplines to like stakeholders and so on, but blending disciplines. And we need more venues to also encourage that kind of work and interaction. And I know I didn't answer your question.
No, that's great. Like, because you could ask the question, I don't. It's like, what should we do after cultural data analytics? But now I want to go to Mike's questions.
Okay, thank you. And it was very interesting and sort of kind of fascinating sort of place to apply the network science and generally complex systems perspective. I wanted to go a little bit deeper, for example, into this example you gave us, this structure of document and cross references, and it, apart from it being beautiful, which is without any doubt is, I was thinking what sort of research questions you may ask looking at this picture. And I came up with sort of several which I would like to throw in and then ask you to maybe iterate on this, or maybe tell us what sort of questions you ask. But we'll see. One is basically, do different legal systems differ in with respect of how they structure these things? And secondly, you mentioned briefly, and maybe it is indeed true that when the document gets amended, it goes from sort of regular structure to sort of more resembling random tree. Number three, I guess, is does it make sense to ask what is the optimal structure, for example, in the sense that maybe minimizes cross references which are far away from each other, whatever, and does it indeed influence how people can use it? Is there any way? And number four, is there any way to measure what are good and bad practices in terms of how people who use the law actually apply these things? Well, that's very informal and just what came to my mind when looking at this picture, and maybe you have something very different to say. But
yeah, so I can give brief answers to almost all of these questions based on like the limited explorations that we've done so far. So we've looked at the question at a very high level of how legal systems differ in like one body of work that resulted in two papers, one being like communicating more toward the physics community and one communicating more toward the legal community. So basically using the same results, but once we sold it as like structural comparative law, so a method of comparing legal systems, and once we like basically cast it as like the paper is called Measuring Law Over Time in Frontiers in Physics. So it's much more complexity oriented. What we see there, I mean, apart from the problems of comparing apples and oranges with limited data. So we looked at the same time frame for Germany and the US at the federal level, legislation and regulation. And that already means we're not having the same content covered, right? And so the only reason why we did that is because we needed to start somewhere, and the ultimate goal is to actually compare the full systems. What we do see, though, is one striking difference is, and now I'm formulating this in computational terms, Germans like call by reference, and Americans like call by copy. And so when Germans have the content of some rule that they want to refer to, they actually refer to it. And what we see in the US code, for example, is you have a lot of really verbose duplication. And that also leads to inconsistencies, which already brings me to, I guess, kind of the fourth question about like bad practices, for example. So we have one paper that's called Law Smells, which takes the code smells literature for refactoring and looks at different bad smells that you might have in legal drafting. And so that could be like you have huge blobs of text that are unstructured, or you could have like long or elaborate reference trees that are hard to manage from the information theoretic perspective. You might see something like dynamically that there's shotgun surgery where there's little changes made everywhere, or there's kind of data that's lurking around in language, things like that. So I think one can, for example, draw on what we know about code and how we can make code nice and maintainable to transfer some of that to the legal domain. Similarly, when we look at changes to documents, one paper, it's in German, where we looked at evolution of specific legal acts over time, including kind of the Securities Trading Act in Germany. And what you see there is, this is kind of like, at least at the local level, we found that pattern, but I wouldn't generalize it, although my hypothesis would be that it generalizes, is people are less prone to changing older laws that have like more of an aura to them than newer ones. And then there's like one big organization that induces change in like national laws, and that's Europe. So what you see, for example, is that there's something that has been legislated at the national level, and then there's no need for that anymore because Europe now made a regulation that's directly applicable, or you need to implement a directive, and then you're going to change there. So what you see is that there's very distinct patterns to where things get changed. Again, like studying that completely over time requires data that we don't also have in the same way. One earlier investigation that I did is, for example, that more political material in the civil code gets changed more, which is like pretty obvious. But so, for example, in family law, we've seen many more changes than in inheritance law. But really, I mean, this is like very basic stuff. And this is one of the nice things about this field is like basically nothing has been done. So you can do a lot of things that are like super intuitive to do. And it's like, what about this? I wonder about this. If I just had the data. And now one thing that we're doing in the lab is we're trying to improve the data situation for everyone, because getting the data right is one of the very hard things. What is the optimal structure? So I've talked a lot about work that I've done myself. One work by Pier Paolo Vivo at, I believe, King's College London has looked at information processing in legal trees. So they took kind of the tree structure. So they're physicists, and it's a very physicist paper. And I think you can legitimately criticize it from some of the semantic, more legally informed perspectives. But basically, they took trees and looked at information processing and how you can find information in trees and what makes them better or worse. So that's just like a pointer if you're interested in optimal tree structures. I think in general, what we found to also work quite well in terms of intuitive alignment of results with method is anything that's random walk based, which is unsurprising given that we're dealing with a web of documents. And so PageRank was based on that. And so InfoMap, for example, is a clustering algorithm with minimum description length, despite all of the problems that it has. For some stuff has worked reasonably well. But again, I think right now we're like in the transition phase where we're doing much more thoughtful and granular network modeling first. And then that will kind of open a whole new horizon as to what we can do on the measurement side as well.
Please, I have a second question. But
go on.
Well, second question, different topic. Thank you. Basically concerning this idea of robustness of legal networks and against hostile takeover, etc. I want to sort of be a little bit of a devil advocate there and ask, well, basically what exactly you mean, because from the sort of general perspective, what you described, you have sort of some sort of political force which won representation in an election. Yes, and maybe all of us dislike this force, but nevertheless it won and got representation, and it influences some sort of a legal system, or it influences the people sitting in the courts or whatever. And how do we define this as sort of as something undemocratic? I mean, we may define it by looking at the views of these people and saying that we dislike, we dislike, or we generally, by some definitions, call these views undemocratic. But structurally, looking at just agents putting some other agents, how to define problems there, basically?
Well, I mean, so that's not a solved question, and that's kind of why it's part of the work program. So the structure and robustness, I'm just going to bring it up again. So I think, let me start by clarifying that, because intuitively, so when we talk about robustness in networks, we might think about eliminating nodes or eliminating edges and see how many eliminations it takes for the system to fall apart or something, or for a certain process that we model on the network to not work anymore, or for percolation or whatnot. So when I'm talking about robustness of legal systems, I think the start of the formalization would be, and this is very, very much in the early stages of thinking, right? Because we don't even have kind of the algorithmic structure of the system that would allow me to simulate anything. And this is also why I think that we'll need simulations already in the measurements, because inherently something like robustness also in networks is kind of based on simulations. So I think you can start by asking a very simple question. So how much of the system do I need to own to ensure, to have 100% probability that I'm going to get the outcome that I want on any specific thing? Because we're intuitively anchored in this idea of checks and balances, and how much. So basically, say I have just to simplify this thing, I have a court system, and each court has a color, one of two colors. How many colors, how many courts do I need to flip to ensure that in a certain amount of cases I'm going to get a certain outcome? And this is so it's all based on starting with the simplest possible model and then gradually increasing the complexity while ensuring that you actually work into the direction of kind of construct validity. And so I think we need to be very honest here that any talk about robustness and resilience and adaptation is very normative in the sense that it assumes some function. And this is also where I think we really need to bring in legal theory from the actual legal theory perspective, because there's even disagreement among lawyers as to what the function of a legal system is and even what a legal system is. But so I think robustness makes only sense if we're very clear on what the function is. And I think that's something where also, I don't have a clear answer yet, but I can tell you that if you have this picture of what you think function is, then this is how we would measure robustness. And so you can make it dependent on all the assumptions that you then make explicit as well. But there's a lot of conceptual work to do where you need to care about construct validity when you're measuring anything.
Yeah, and it's certainly just thinking of sort of cases where we do probably agree that there's the sort of court capture actually happened. I don't know, in Hungary, whatever. I think that any way of modeling it should have some sort of element of an evolving network. So as the capture happens, the rules of the system happen. So if at the start of the evolution it seems like you need one amount of power to control everything, then it somehow evolves in itself when you put people. The rules evolve so that the amount you need to capture the system changes.
Well, that's why you have structure, function, and dynamics in the sense that then dynamics.
So there's some sort of tricky interplay. Yes.
Well, I mean, that's kind of when you do kind of computational institutional modeling. And this is like you'd start at a very coarse-grained level, right? Where you just have like the institutions that we know that are in the Constitution and what they can do with each other. And then you have like, we have rules for making changes to rules. And so this is kind of like one of the things here, for example, like, another way of like achieving domination here would just be to add like 4 red guys to that court, which is like a change to the rules. So we do have this interplay of structure and function in the legal system, but even like on a static level, where there's always like there's a dynamic component in a static measure that is based on a simulation, right? But you just assume that the structure stays stable for some time, and there'll be some delay in the action. So I think it's like fair for some element. You can look at and what now or what if. Like, so for example, one thing that I find very interesting and kind of concerning that we haven't looked at it is the effect of temporality shifts on the power distribution in legal systems. Because people are pretty like free to call snap elections recently, or like there's been a lot of snap elections in different countries. And especially if you have a federal state system where there's federal states and like a central a nation, you have election cycles that are usually like deliberately not synchronized, for example. And so there's always some election going on somewhere, but there's some non-synchronization or synchronization. And when you call a snap election, unless you do it the way that it normally doesn't work, namely that you just elect people for the remainder of the period, you just elect for the new period, right? But again, it would be like 4 years or 5 years or so. You shift the temporality. And that can actually, in a multi-layer system, really impact what you can do where, because then, you'll have people running campaigns in this part of the sphere and so on. And so this is like even statically when nothing about the fundamental structure changes, just the temporality of when we make new decisions can already do a lot. But it all kind of hinges on having some computational representation of what do we actually have, who can do what with whom, and then you start making assumptions that with a certain probability this will happen at this time step. And it's like start like super naive models, and then you start from there.
So there's a sort of you could say the paradigm shift from structure to function was in network science. It was this thing. Oh, okay, we shouldn't look at companies. We should look at the interactions of companies. In art history, it was let's not look at paintings, but let's look at the interaction between artists and donors, and what people actually do in a painting and stuff like that. There was a person called Ernst Cassirer who in 1910 wrote this book called Substance and Function, where he makes exactly that argument. And sort of from that follows a lot of stuff, which computation physics, whatever, like what he explains seems to be all rooted in Leibniz. And there's a sort of really, really interesting, striking take home, which I think is sort of, there's a book in the 1980s called Archaeological Constructs by a guy called Gardin, who shows this in a single picture. Like any explanation about any historical process in archaeology requires dynamics and function. So there's no such thing as sort of like explaining something just by the structure. While for a long while we have done this, right? I mean, there's archaeologists who would still say the geographical information system is the basis of archaeology, as if the structure of like how bones are spread out in the landscape is sort of like explaining culture. But of course, it's the function that leads to that distribution. And so in some sense, this is sort of like underlying everything. So shouldn't the thing not be the opposite way around? Like obviously structure, function, dynamics is a classic sequence of any network science overview picture, structure and function of complex networks, Mark Newman, 2003. At some point, people look at temporal networks, so we get the dynamic stuff. But actually, shouldn't we do it the other way around? Like, shouldn't we actually look at what's actually flowing across the system? What's the input and the output? Like, what Leon Chua and what is Klaus? Forgot his last name. In sort of like claimed would be the hardcore of network science would be to look at the circuits and basically the kind of dynamics that's going on the circuit that is the network. And so in some sense, you have this, like you even spell it out, you have a system where there's input and output, you get an environment, which seems a lot resonant with Uexküll's Wirkungskreis, which is the double feedback loop of inside and outside. You have cognition and there's a feedback loop with environment, and there's a feedback loop with your own imagination of the environment in a sense. And so in some sense, we end up in a situation where it all of a sudden looks like a large, messy electrical engineering network where we need to make sense of a system where we're totally, like, neither legal scholars nor computer scientists nor regular metric scientists are equipped for, because the process that's actually happening is much more sophisticated than we thought.
Well, so I mean, I'd want to distinguish the system that we're looking at here from kind of the way that structure is used, for example, when people are looking at archaeology. Because so here we're dealing with a system that's partially, at least, human engineered. So in the way that we control the generating processes of the system is by making changes to the infrastructure. That's like the most direct way that we have, apart from like influencing the people that are doing stuff. It's like, so we can decide which organizations exist and which organizations can do what with whom. And so in that sense, there's more engineered structure than in many other systems that are studied by complexity scientists, in the sense that we actually have a lot more human engineered structure. And that is stuff that we can immediately influence once we understand how it interacts with like the function that it produces and the dynamics. So
isn't that the exact point? Like, that our imagination, and archaeology is also true, our imagination is guided by the ontology that we construct. Like, we come up with a law because people sit together and think, oh, people do the following things in society, and you cannot take objects out of the handbag of somebody else. We call this stealing. Obviously, somebody had the idea to define it like this. So that is a human imagination. And then there is a process of people taking things in their hands, from handbags, from tables, from shelves, where some things are illegal, sometimes are illegal, but there is something happening in the real world, and these two things have a sort of relationship. And the one thing that happens in reality is probably the more complex than our own imagination, simply because we're a corner in the universe and our imagination is limited, even if there's 7 billion people. So the question is, isn't it like exactly what you're doing? You look at actually what is the complexity of that imagination in relationship to the measurement of what people actually do, which in some cases, if you have court proceedings, this is probably containing both of these kinds of information, isn't it?
Yes. So, I mean, like, I think the main point of the structure function dynamics here in the way that I use it is you cannot understand function without accounting for the structure. Because like the structure that we put into the courts, and like what you observe, so you might observe that a certain panel renders a certain decision, and it has a certain, like, it talks to certain points, cites certain other jurisprudence and so on. You could probably reverse engineer a lot of the structure that we formally put into the system from it, from like the data that you observe in function, but not all of it. And then looking at that, like where it differs and where it's the same, is actually quite revealing. Because that can also tell you that maybe we're making a distinction here structurally that we shouldn't be making, because reality isn't holding up. And so kind of this court is doing this other thing as well, because it's just like what we had in mind in our imagination as like the cases that it should have don't actually exist in the same form. So I think that the moment that we have like a human specified, human engineered system, where we might have an ontology that says like, you're doing legislation only. And so courts, this is also a common moniker, like when we're in civil law jurisdictions, courts don't make law, right? They're not supposed to. Like in common law, that's fine, but like not in civil law. And then you look at certain areas of law, say in Germany, and you see how much of the like legal decisions, judicial decisions, is just based on other jurisprudence and not at all on statutory law. And then like it's hard to escape the conclusion that maybe there's some lawmaking happening here, regardless of like, of course, if you define lawmaking as what the parliament does, then that's not that, but functionally it might be equivalent. So accounting for the structure allows us to challenge our the distinctions that we're making.
That is super, super interesting. So you made a comment during your talk where you defined, or you said procedures are like algorithms, which, sort of literally translated they are, right? Like there is something ongoing and sort of like there is a defined sequence, so let's call it an algorithm. But where you positioned procedures in your diagram was within a system that was sort of reinforcement learning, and there was an input and an output. And I have this sort of pet peeve. This is similar to your use of regular expression. Like anything that has an input and an output is a filter. And the interesting thing is that if you take this literally, like in audio engineering, then if you want to make music with this, you want to have control voltage on the filter. And so something that you put in, not just the signal that's like, two people have a car accident, they walk in the court, that can be an input, but the other people in this room also have an input for different reasons, and because they have done many cases with similar car accidents, and there was somebody wearing a blue shirt and this guy wears a blue shirt, so they may think something, and that may be a weird input that is not an official input, which changes the procedure and the algorithm and changes the output of the filter. And you may get emergent signal that is very similar to whatever happens in a synthesizer patch where you would like to do music, but something completely different comes out than you think should come out. So the question, does this filter analogy sort of like make sense in a sense to capture things which are not at all, not just emerging complexity in the sense of self-organization of parts that are there, but there is some other dynamics that emerge on the system that are not even part of the record, but still sort of like change the system in a sort of like crucial way. It's hard to explain, but like the audio analogy, I think, is a really interesting one. So there may be noise emerging from, you have a particular court situation and then have an output, and just by that repeating over and over, for example, the NSU cases in Germany probably changed the whole political situation of like how people looked at right-wing parties, even though that wasn't the subject of this thing, but it was constantly, there was an output to the media. So that's exactly one such thing, right?
No, I think this is a very good point. I would argue that like capturing that requires us to first capture like the formal stuff that's there.
Yeah.
And so this like goes back to one discussion that I've been having a lot also with like legal theorists and legal scholars in general. It's like, what about legal culture? They always ask that. Like, how are you going to capture legal culture in your model? And like my answer to that is like legal culture is what remains when you account for all, like when you control for all non-cultural variation.
Okay, yeah.
So right now, if you look at the German legal system and the US legal system, you might get different outputs for all kinds of reasons. You might have a different case distribution just because there's different people there and so on. There's some performativity also in both systems. And just like, the kind of reinforcing of differences because we have different systems. But we currently don't, when we compare, we have no way of controlling for the different allocation of competencies, for the differences in institutional setups, for the differences in procedures, like who can do what with whom. But if you controlled for all of that, and let's assume that we're in this great world that we can do that, then what remains, where it's like you have a different outcome, and say they have like two systems that have exactly the same structure and exactly the same case load, but they produce different outcomes. That's kind of culture. And so I think at a more micro level, you could ask similar things for like, it looks like it's exactly the same case, but there's a different outcome. And then why is that? And then that's something that cannot be captured by my data or isn't currently captured by the data. And that could kind of arise from that kind of noise that we get on the filter.
Super. Now, we have only 15 minutes to go. This is super exciting. And there is one thing we shouldn't leave out, like the big elephant in the room, hostile takeover of democracies. And boils down to one question. Like, you do something very sophisticated. If you're successful, that's awesome. You already got an ERC starting ground for it, so people have expectations. The key thing is if it works out, like everything awesome, are you afraid that it could be weaponized? Or is it already weaponized? Or like, let me give you an example. Bob Mercer did cultural analytics in Renaissance Technologies, a hedge fund in 1995, at the same scale we do it right now. He knows what it means to induce noise into systems, high frequency trading, and he funded Donald Trump bullshitting on Twitter in the first round. And now we got sort of something that's way more up your alley, which is Project 2025, where people, if you want to be generous, worked till 1964 to actually do exactly that, sort of sway the system by many, many different needles of attack and many billions of dollars by now. And it seems to me like somebody who would have your toolkit would be even better at that. And with the latency that you have shown in sort of like the legal process, isn't there like a kind of like Manhattan Project moment that we need to actually defend democracy really hard, and probably not with 1.5 million, but better with €1 billion?
Yeah, I mean, I do have a footnote on the potential misuse of outcomes. And it's interesting because it also ties back to a discussion that emerged around the recent release of a study done by the Verfassungsblock in Germany on like, I forget what exactly it was on, but something around like judicial independence or so, where people also had to answer the question, like, you know, with this information, do you not think that you empower the bad guys? And I would agree with you that like the bad guys are already empowered. Like many people are already doing that, like for much less benign reasons than my scientific curiosity. And currently what we have is that our institutions, our democratic institutions, are operating in a small data, small epistemological capacity regime, whereas powerful adversaries are operating in a big data, high capacity regime. And so I think anything that can help level the playing field a bit would be useful. So, I mean, maybe like the tools that they're using right now are less powerful than what we could do with our systems. I'm not sure about that, honestly, and I think we just shouldn't underestimate the adversary. I mean, that's ultimately probably a lot of the stuff that we're coming up with. You know, if you just have like, you know, you do attract intelligent people to the dark side by lots of money, I think these things can come out of that. And so we shouldn't just act like we can protect our democracy by like not knowing. And I think like choosing ignorance, like that's naive to think that it's not going to be done. Like if we don't do it as the good guy, it's going to be done by the bad guys. So I think that's one thing. And then like how much money should we throw at the problem? Yeah, probably more than 1.5 million euros. I must say that there's been quite a bit of funding that goes into that direction at the European level, at least, like democracy and like different consortium projects, and like both Pillar 1 and Pillar 2 have gotten funding for different methodological approaches to that same problem. I think there could be more like coordination around these as well. Probably also a thing where we really need to think about how we can combine resources from different disciplines and different specializations. Because I think like once you have this can be like a great transparency tool. But what we need to match that is the epistemic capacity on the civil society level, which then is something where you need a lot of, for example, media studies or like polarization studies and so on. And so I think this connects to a lot of other parts where people study like seemingly very different things, but for like democracy to work in the future, or for like legal systems to remain functional to what the, like, let's say very normatively defined goal of like fostering kind of human capacity development. Let's say I'm very Martha Nussbaum on this, like, and not disempowering people, like empowering people to develop their talents and giving people chances to do that while maintaining our planet as a livelihood. And like, so all of these things, like a sustainable, ecologically, economically, and socially sustainable societies. So what legal systems do we need for that? I think that's a strong civil society component where we're currently seeing challenges by the way that technology is used to essentially make people like both addicted and stupid. So I think there's a lot that where one needs to kind of cross over, think about how we can get out of that trap, because that's also fundamentally like if you trace it higher, like back enough, you have the same people with the same interest underlying all of that. So
No more questions? Thank you very much. This was amazing.
thank you for having me.
Next week, we're going to be at the University of Amsterdam. That's a premiere cultural data analytics open lab seminar from a different place. We will visit the lab of Monica Kakowicz in the business school of University of Amsterdam. That may be an unexpected place to find cultural data analytics, but they do it at industry level, including fashion. So that's a good sort of aesthetic conclusion before the holidays. Thank you very much. See you next week.
Thank you.